WWF has provided two amicus curiae briefs to the Tribunal in case number 21, the request for an advisory opinion submitted by the Sub-Regional Fisheries Commission. Those briefs are available on the website of the Tribunal. They go into some detail, and it's not the purpose of this short oral statement to reiterate them. Everything set out in our amicus briefs still stands. However, in just a few minutes now, WWF would like to make 3 points drawn from them. The first relates to the responsibility of flag states, the second to flag state liability, and the third point relates to the duty of coastal states under paragraph 1 of Article 63 of the Law of the Sea Convention. The responsibility of flag states is raised in the first of the 4 questions posed by the Sub-Regional Fisheries Commission. WWF submits that there is an obligation on the flag state to ensure that its vessels do not undertake IUU fishing in a foreign state's exclusive economic zone. The legal basis for this obligation is explained in our first brief. We consider that this obligation is one of conduct, and within that, an obligation of due diligence. To quote from paragraph 110 of the Seabed Mining Advisory Opinion of the Seabed Disputes Chamber of the Tribunal, this means that it is an obligation to deploy adequate means, to exercise best possible efforts, to do the utmost to obtain the result in question. In our first brief, we set out some of the measures that we consider should be deployed by the flag state. Our second point relates to the liability of flag states. This matter is raised in the second of the 4 questions asked by the Sub-Regional Fisheries Commission. WWF submits that a flag state which is in breach of its due diligence obligation to ensure that its vessels do not undertake IUU fishing in a foreign state's EEZ is liable for any damage caused by that breach. In turn, the flag state must make full reparation to the coastal state concerned for that damage. Compensation is the appropriate remedy where the breach causes damage that cannot be made good by restitution, but is nonetheless financially accessible. And WWF considers that compensation may indeed be effective in the case of IUU fishing in an EEZ, where IUU fishing has occurred as a result of a breach by the flag state of its due diligence obligation. The flag state must then compensate the coastal state concerned for the income lost by the coastal state as a result of that IUU fishing. We go into more detail in our first brief. Our third and final point in this short oral statement relates to the duty of coastal states, a subject addressed by the 4th question of the Sub-Regional Fisheries Commission, and in particular under paragraph 1 of Article 63 of the Law of the Sea Convention. Article 63.1 addresses cooperation between coastal states in respect of stocks which occur within the EEZs of 2 or more coastal states, so-called shared stocks. For such stocks, the coastal states concerned must seek to agree upon the measures necessary to coordinate and ensure the stock's conservation and development, albeit without prejudice to the other provisions of Part 5 of the Law of the Sea Convention. We consider that the duty in Article 63.1 has been relatively overlooked compared to, for example, the duty in Article 63.2 regarding straddling stocks. Yet we submit that the Article 63.1 duty is very relevant in the current proceedings. And this is because the Sub-Regional Fisheries Commission's 4th question expressly mentions small pelagic species, and in many cases, stocks of such species will be shared stocks. We submit that these proceedings are an excellent opportunity to explore the meaning of Article 63.1, and so help coastal states to better understand their obligation to cooperate. And we very much hope that the Tribunal will feel able to use this opportunity. In particular, WWF considers that pursuant to Article 63.1, coastal states should jointly develop a cooperative management arrangement for shared stocks. This arrangement should be put in place before any one of the coastal states issues a permit to fish the shared stocks in its waters, whether that's a permit to its own fishers or to other states. The management arrangement should be founded on proper conservation and management measures. In our second brief, we've provided an analysis of the wording of Article 63.1 and some references which we hope the Tribunal may find useful. To finish, we would like to reiterate the following three submissions. First, there is an obligation on the flag state to ensure that its vessels do not undertake IUU fishing in a foreign state's exclusive economic zone. This is an obligation of due diligence. Secondly, a flag state which is in breach of this obligation is liable for the damage caused by its breach and must make full reparation to the coastal state concerned. Thirdly, Article 63.1 on the management of shared stocks is an important but neglected provision, and we very much hope that it will enjoy a raised profile as a result of these proceedings. Thank you.